Welcome to meeting number 19 of the House of Commons Standing Committee on Justice and Human. I haven't even gone through the instructions yet. Can I finish this? Okay, good. All right. Pursuant to the order reference of October 1, 2025, the committee is meeting to continue its clause-by-clause study of Bill C-9, an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural places. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Is there anybody on? There's nobody on Zoom. Okay, so I'm going to skip that then. I'd like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic. Reminder that all comments should be addressed through the chair. And then I would like to welcome our witnesses from the Department of Justice. We have Chantal Ramcharan, Deputy Director General, General Counsel, Criminal Law Policy Section, and Joanna Wells, Team Lead and Senior Counsel, Criminal Law Policy Section. So we are continuing the debate on Mr. Lawton's sub-amendment to Madame Latanzio's amendment. And then when we are done with those two, we will go back to Mr. Brock's sub-amendment to CPC 8.1. So where we left off was the amendment proposed, the sub-amendment proposed by Mr. Lawton. And what I'm going to do to start is, because at the end of the meeting, Mr. Housefather and Mr. Baber had both made some submissions on whether it was admissible or not. There was a lot going in the room, and I wasn't able to hear everything clearly. So what I'm going to do is ask both of you to repeat what you said on Monday to start. So I'll start with Mr. Housefather, and then I'll go to Mr. Baber.
Okay, so thank you, Mr. Chair. So basically what occurred on Monday, feels like forever ago, was that Ms. Latanzio proposed an amendment that would clarify the state of the law with respect to when you would not be charged with willful promotion of hate. And Mr. Lawton had proposed a sub-amendment to remove the last part of the sentence, if they do not willfully promote hatred against an identifiable group by communicating the statement. That was the sub-amendment. What my representation, Mr. Chair, was, and in the event you rule this in order, I'll have substantive arguments against the sub-amendment by Mr. Lawton. In the normal course, simply removing words from an amendment would be a perfectly legitimate sub-amendment. But in this case, what Mr. Lawton is proposing to do would not be valid because it goes completely against the intent of both the amendment of Ms. Latanzio and the bill. So it could not have been proposed as an amendment in a standalone basis, and let me explain why, Mr. Chair. Ms. Latanzio's amendment was clarifying the law when someone could not be prosecuted. Mr. Lawton's sub-amendment changes the law. Mr. Lawton's sub-amendment would essentially mean that anybody could communicate a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate, and then not be charged with willfully promoting hate, even if they were not in good faith under the Keekstra case. And as such, Mr. Lawton's amendment changes the state of the law, and it changes the intent of the bill, because the intent of the bill was to give greater protection to minority groups targeted, and Mr. Lawton's amendment would essentially do the reverse. It would create a new state of the law, and I'm sure you can clarify that with the officials. It would create a new state of law, and that way, Mr. Chair, I don't believe that it is a valid sub-amendment. I think there's other ways of phrasing this that would be more palatable. Thank you.
Thank you, Mr. Housefather. Mr. Baber.
Thank you. Mr. Housefather's submissions spoke to the admissibility of the amendment. There's nothing precluding us from amending the law. There's nothing precluding us from amending the bill. That is the entire reason we are here. I'll start very briefly with the fact that the amendment cannot be ruled out of order if it basically seeks to delete, the sub-amendment, if it basically seeks to delete a portion of the proposed amendment. This is precisely what a sub-amendment is meant to do. I think Mr. Housefather's concern is more of a substance and policy. I actually don't agree with Mr. Housefather that the deletion of the last line and a half would not be in line with the intent of the bill or the criminal law as it is now or will become should this bill pass. But that is a substantive argument that my friend is making. And as such, I kindly ask that you allow the amendment to be in order.
Thank you. I'm going to ask the officials if they have any comment on this, not on the procedural component, but on, I'd like you to address Mr. Housefather's point on whether this changes in substance the nature of the amendment with respect to the bill.
I can speak quickly to that. It would change the substance of the proposal.
All right, thanks. Look, I've reflected on this over the last couple of days. I mean, my job at this point is to determine whether it is procedurally admissible. I've listened to Mr. Housefather, I've listened to Mr. Barber, I've discussed it with the officials, and I'm going to rule that it is admissible. So we will proceed on debate on the sub-amendment. We'll start a new speaking list.
Point of order.
Mr. Lawton.
Just hearing Mr. Housefather's concerns on this and having reflected on it as well, if the purpose of what the Liberals are seeking to do through Ms. Latanzio's amendment is truly to send a signal that religious texts and the expression of religious sentiments will be protected, I can propose an alternative by which the sub-amendment would be withdrawn. If there is unanimous consent, this is what I'm seeking, withdraw the sub-amendment and undo the adoption of BQ3. Reinstate the religious defense as is, and we have the perfect clarity that the law needs. Okay.
I will ask the question.
Sorry, I see Liberals laughing at religious freedom, so I guess that's a no to unanimous consent.
Mr. Lawton, hold on, everybody, please.
If you want clarity, it would give clarity. That was the.
I don't think the commentary about interpreting other people's physical expressions is necessary or an accurate reflection. I will pose a question. Do we have unanimous consent on what Mr. Lawton is proposing? No. Okay. All right. Okay, thank you. So I will now start a new speaking list on the sub-amendment proposed by Mr. Lawton. Yeah.
Monsieur le Président.
Yeah, hold on one second.
Mr. Chair? Yes, Mr. Fortin. I just want to be sure that we're all talking about the same thing. So there was the proposed amendment 8.1, and for 8.1 there was a sub-amendment that was presented by Mr. Brock, and is been set aside, it's parked, and now we are discussing Ms. Latanzio's proposed amendment to add clause 11.1 and the sub-amendment of the Conservatives that is to strike out part of that. Is that what I've understood? So, given that there is no agreement on Ms. Latanzio's amendment, shouldn't we go back to 8.1 and the sub-amendment proposed by Mr. Brock?
In terms of where we are in the proceedings, but we have to, if there is debate on the sub-amendment, we'll hear it and then vote on it, and then we'd have to continue the debate on the proposed amendment, whether it's amended or not, and then vote on that before we can go back. So that's where we are. So does anybody, Mr. Brock, you had your hand up, but this is on the sub-amendment? Okay. Was there anybody else?
Yeah.
Mr. Housefather, Mr. Barber, you're nodding. I'm already on there. You're already on there. Okay. All right, good. Okay, Mr. Brock.
Thank you, Chair. I want to acknowledge that it's 5:15. This meeting started at 4:30. For Canadians who are most definitely following this discussion, this debate, we owe it to them to explain what transpired. And what transpired has been partly put on the record, but there's other aspects to it that require clarification, Mr. Chair. So following the meeting on Monday, I'm aware that the Justice Minister, Sean Fraser, did an interview with iPolitics, and the headline reads, Fraser says Liberals hopeful of a compromise with Conservatives on C9, but won't wait forever. And that's followed by a direct quote from the minister that reads, "We won't let perfection be the enemy of progress for much longer." I'm not reading the entire article, but certainly some portions of it. Justice Minister Sean Fraser is refusing to close the door on negotiations with the Conservatives on changes to the government's anti-hate bill, but acknowledges he'll eventually move ahead with the legislation if no agreement can be reached. At Justice Committee on Monday, the Liberals proposed changes, which is the Latanzio Amendment, to a contentious amendment to Bill C-9 that removes the religious beliefs exemption for the crime of inciting hate. The Liberals said they were looking to clarify that Parliament wasn't intending to criminalize religious speech, but the Conservatives argued what was being proposed didn't address real concerns from faith communities. Speaking to reporters before Tuesday's cabinet meeting, Fraser said he's still hopeful the Conservatives can be brought on board and urged members of the committee to find a compromise. It is within that spirit that we took a look, the Conservatives took a real hard look at Ms. Latanzio's amendment with Mr. Lawton's sub-amendment, and we were also guided by communication that we received, that in fact the entire committee received, from Mr. Derek Ross of the Christian Legal Fellowship, who professed his disappointment that the discussions he had with the Justice Minister in proposing certain language to compromise the drift or the rift between the Liberals and the Conservatives on this issue wasn't actually reflected in the Ms. Latanzio amendment. He put
Mr. Chair?
forth some suggestions by way of changes.
Mr. Brock, I think we have a point of order.
Mr. Chair, I have a point of order. I appreciate my colleague going through a chronology of events in the last 48 hours, but I would like to, at this point, also make it clear, and I think it's important for stakeholders who are watching us, that we started this meeting 35 minutes later, not because of we weren't ready for this meeting. What we were actually doing is trying to negotiate our way through in good faith to try to come to an agreement on a language that would
Chair,
put...
Chair, with respect, this is
No, I'm
not
sorry,
a
I'm
point of
at-
order. I had the
Hold on.
floor.
I know, okay, hold
and I
on,
was-
both of you, please, just wait a moment. Mr. Brock, her point of order is allowed because she is addressing the issue you were speaking about. Whether or not it's relevant or not, just let, I'm going to hear her out.
I didn't finish my argument.
I'm going to hear her
I don't
out.
need Ms. Latanzio
Okay,
to
Mr.
finish
Brock,
my
thank you,
argument for
thank
me.
you. I'm going to hear Ms. Latanzio out.
It was the following, is that the Liberals, the Conservatives, and the Bloc Québécois collectively want to put an end to this filibustering on Bill C-9. We have tried, as you have noted, Mr. Chair, with regards to my amendment presented last week, to clear up the language. The minister has been very clear that he wants nothing more than have C-9 adopted by these committee members and open to any suggestions that would make the bill more acceptable for all parties so that we can get on with it. And I fear, Mr. Chair, that we are using yet again, an opportunity to filibuster through C-9 this evening. So in good faith, the three parties have met in the last 30 minutes to be able to come to an
We're on a point
agreement.
of order. I'll get
And
to
I
it.
don't want to have stakeholders have, I don't
We're
want
not hearing a point of order.
to have the impression that we did not, in good faith, try to work through this through. And that was the reason why we started at 5:05.
Thank you, Ms. Latanzio. I'm going to turn the floor back to you, Mr. Brock, unless Mr. Baber has something he wants to add.
I want to add
Okay.
that was completely a non-point of order, Chair. You allowed Ms.
I
Latanzio
did, and
essentially
we've heard it,
to
and we can move
paraphrase
on.
my argument. I'm
Well-
more than capable of forming an opinion on my own
And Mr.
without the
Brock,
help
and
of any
Mr. Brock,
liberal.
I'm more than capable of determining whether it's a proper point of order, which I did, so please carry on.
So in addition to what Ms. Latanzio had to put on the record, I was optimistic after I read that report that the door had not been closed to future negotiation on terminology. So after we received the proposed new wording from Mr. Derek Ross, we took it upon ourselves to put forth new language that I ultimately shared with the Justice Minister. Before question period today, I crossed the floor, not permanently, certainly not permanently, but to engage in a conversation with the minister, and I actually thanked him for the article, for the language that he used, for not closing the door. And he made it abundantly clear to me that he was happy with language that would satisfy not only the Liberal bench, but the Conservative bench, that he wasn't completely married to this particular language. But he never indicated at all, Mr. Chair, that there would be a poison pill that I essentially learned when Ms. Latanzio and I had a conversation before you gavelled in. And the terms that we received from the Liberal government was, if we accept this new terminology, this would have to end the filibuster on the removal of the religious defense that Canadians and faith leaders have enjoyed for 56 years, that there would have to be a buy-in at the leadership level, and, moreover, that we would finish clause by clause today on Bill C-9. The buy-in from leadership and ending clause by clause was never communicated to me by the minister himself. I learned about this for the first time after I spoke with Ms. Latanzio. We both agreed that, of course, we need some time. I need time to share that with my team. I need to share that with my leadership. We asked graciously if you would agree to not gavel in or simply stand down to allow these negotiations to take place. Unfortunately, because we've only heard from one stakeholder with some proposed changes, we were not in a position to communicate with the upper echelon of our party because they were simply not in Ottawa, so we needed more time. I explained that to Ms. Latanzio. Ms. Latanzio made it abundantly clear that we would not be getting further time and that this language, this new proposed language, would therefore be off the table. So it's disappointing that on the one hand, the actual minister who is responsible for this justice file, who is responsible for Bill C-9, wanted to work with us in good faith, pardon the pun, and negotiate in good faith, and give us an opportunity to come to an agreement, only to be time limited now by the parliamentary secretary. That is not the definition of collaboration. It is certainly not the definition of working in good faith. So that's what I wanted to put on the record, Mr. Chair. I will cede my time to another colleague to continue this discussion, and I wish to put my name back on the list. Thank you.
Thanks, Mr. Lawton. Mr. Brock, rather, Mr. Lawton, before you get, look, we've been dealing with this bill for some time now. I think everybody is dealing in good faith. Attempts to resolve it are happening in real time. I hope we can get back to a discussion about what we are doing rather than focusing on what we're not doing right now, and then we can move forward and get this meeting on a productive footing. So, Mr. Lawton, over to you.
I will yield my time to Mr. Baber, but if you could re-add me to the speaking list, please.
You don't have to yield your time. You're on the speaking list. So.
Cede my time, rather.
Mr. Baber, over to you.
Thank you, Mr. Lawton, and thank you, Chair. Sometimes I pinch myself on this job, even though I've been here for almost 10 months. Sometimes I have difficulty appreciating the seriousness of the consequences of what it is that we actually do here. We have stakeholders in the gallery that I recognize personally who are very passionate about the proceedings of this committee. And I'm of the view that given the importance of the issue that we're dealing with right now, which is shaping this willful promotion of hatred section that the bill seeks to amend, we cannot get this wrong. And I also would like to remind my colleagues that I look at my role on this committee as more of a professional and technical role, and not necessarily political. And so looking at what has been brought forth by Ms. Lattanzio and looking at Mr. Lawton's sub-amendment, I'd like to begin by saying, please, let's slow down, because this isn't great. And I think I'm being complimentary. To start with, what Ms. Lattanzio's amendment does is it softens up, it tries to clarify 319. It tries to clarify the willful promotion of hatred for greater certainty. And then what your amendment says is, for greater certainty, you are not in for willful promotion, X, unless you engage in willful promotion. Just, if you just, and I'll go to the officials on this one. If you just simply take that section apart, for greater certainty, nothing shall be construed as prohibiting a person from communicating statements on X, not the app, unless they actually promote hatred. So not only does it not clarify, not only does it give greater certainty, respectfully, I think this amounts to considerably less certainty. And I'm making an argument of statutory construction. Could I maybe go to our officials on this and tell me if I'm wrong?
I think what I can try to take this question, Mr. Chair, and I think what I would say to the inquiry is that as drafted, this is a for greater certainty provision, and those are used in the criminal law to clarify the state of the law, to provide an alternative way potentially of saying something to reduce confusion and provide clarity. And as drafted, the intent is to clarify the mens rea of the offense, to make it clear what is or isn't the willful promotion of hatred.
Mm-hmm. And I take your submissions at face value. My concern is with the language, with the very language that Mr. Lawton seeks to delete. Because everything from the word, and by the way, I'll go into the fact that for some reason the section is predicated on the fact that statements are made in public interest. That's already a little odd, in that public interest includes educational, religious, political, and scientific statement. In other words, you have to fit within the umbrella of public interest in order to avail yourself of this certainty. I note that in the existing section, pre-amendment, 3 sub C had a separate section for public interest. If the statements were relevant to any subject of public interest, the discussion of which was for the benefit of the public. So I'm not sure if the intent here, Ms. Wells, is to say you can't engage in educational, religious, political, or scientific debate made in the course of a discussion publication unless it is of public interest. Right? If you read the proposed amendment by Ms. Lattanzio, for greater certainty, nothing in the section shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including ABCD. In other words, do you not read the statement, the amendment, as to say that in order for you to fit within the certainty, your statements have to be of public interest?
Mr. Chair, the language of public interest responds to concerns from stakeholders that the removal of the good faith religious exemption and those statements that might be made in the religious context, for example, would be in the public interest. So I think it's speaking to that concern specifically, but it is a for greater certainty provision that will not change the scope of the offense. It really is to an interpretive clause.
But Ms. Well, whether, again, I appreciate what the officials or what Ms. Latanzio is trying to do. I was actually happy to see this when I saw this. But again, I go back, well, no, but I'm saying this is not good. With respect, Ms. Latanzio, I don't think this is good work. I say this just on a professional level, and I'm articulating two clear concerns. Number one, the official tried, I'm not sure that the official said it's okay. The official tried to explain what the intent is. I'm asking the official about the quality of the language, and I believe that my concern is legitimate. First of all, on the basis of how the section is constructed, do you not read that in order for you to avail yourself of this greater certainty, the statements must be in the public interest?
Perhaps I can attempt here. So it captures, like, the clause reinforces the high threshold of the offense, right? So the for greater certainty clause has to be read in conjunction with the offense. And the objective of the for greater certainty clause, and also to respond to what you're saying, is like how it would be interpreted, is that it provides examples of the expressive activity, debate, discussion, and political, religious, educational matters. So these are illustrative examples and aren't meant to be an exhaustive list. And so public interest is broad. It's a very broad concept. And so you've got public interest and you've got the illustrative examples. And it is, like my colleague said, with a view to providing certainty, greater certainty, and in how this offense should be interpreted.
Please, this is just a purely discussion about statutory construction, just about how this thing is drafted. Could we please look at the section? Nothing is prohibiting a person from communicating a statement on a matter of public interest, including educational, religious, and political. In other words, what you're trying to say is, in order for you to be able to rely on this interpretation of the section, it has to be in the public interest. And the reason I'm afraid that this is how it's going to be interpreted is because of the word including. If it was on a matter of public interest, on a matter of educational, religious, political, etc., I think there are some additional lawyers around the table that are not necessarily sitting on this side of the room that understand my concern.
I do hear what you're saying. So, I appreciate that. I think the way that you could read it, and with the intent, is that a statement on a matter of public interest, that's the broad, general chapeau. And then the including is examples of which. So
that's not, but the word includes, first of all, the word includes doesn't necessarily mean an example. But the problem is, yes, you're right, it's the tunnel. You have to be within the tunnel of public interest. But you can certainly create a lot of, you can conceive a lot of examples of political statements that may not be in the public interest, or scientific statements. We went through scientific statements in the last couple of years that arguably were not in the public interest. The problem is I think the drafters have conflated the meaning of public interest, and what further complicates the situation is the existence of the public interest defense in the existing section. So I am fairly sure that if I was to write this to a client, I would sign my name to my opinion. And the other thing, and now to go back to my original point, which goes to Mr. Lawton's sub-amendment, is that this is basically circular reasoning. You're saying willful promotion of hatred is criminal. For greater certainty, public interest, for greater certainty, A, B, C, D are not prohibited unless they're willful promotion. So that it doesn't do anything. Because you seek to limit, right? You have an offense. You're starting with an offense. You look to limit a certain behavior. And then you say, for greater certainty, I'm not precluding you from doing this unless you engage in the said behavior. It doesn't actually clarify what you look to clarify, because you go back to the operative section. Please, Ms. Wells.
Looking for an answer.
Yeah.
I'm happy to try to clarify again. So a couple of things. So the language of including an education, religious, political, or scientific statement is a very common drafting technique in the criminal code to suggest a non-exhaustive list of things that could be included in the public interest in this particular context. I think when you use the language of like people, how do you avail yourself of this? This is not a defense, and so people would not need to avail themselves of this. It's a clarification of the elements of the offense. So it is a different legal tool that is being proposed as a way of clarifying the scope of the offense.
I'm grateful to you. First of all, I think it's very, very important that you acknowledge that this is not a defense, that we are repealing a defense that the Supreme Court has relied on in part to make the willful promotion of hatred survive constitutional scrutiny. But regretfully, you have not addressed my concern. I know that including educational, religious, political, scientific, I understand that that is a common phrase. But the word including, okay, means that it's subsumed in the phrase public interest, correct?
In the public interest,
of what could be in the public interest. Mm-hmm. But the point is that you may have statements on these subjects that are not in the public interest, because we're not sure how we're defining public interest. What I had for lunch, is that a matter of public interest? I'm asking a serious, this is a serious question, and I think Mr. Housefather agrees with me. It's not a matter of public interest. It may be of interest to my family members or Mr. Brock. Definitely, Mr.
Yeah.
Yeah.
Maybe.
So what I'm suggesting very respectfully is that the amendment is crafted in a way where the certainty is clarified in a manner that in order to get into this clarity, something has to be in the public interest. That is a very serious limitation on the scope of speech that we're looking to protect. So if anything, if we're going to start redrafting this, I would say, please, can you not include all those in public interest, but we need to disjoint them. We need to decouple them. Again, especially because public interest exists in 3 sub C. All right? And the second, it's a standalone defense. And the second thing I'm urging, and this is squarely to the amendment, is I'm not sure what the amendment actually does.
Well, they said nothing.
It says, again, you are, Charles' father, X, Y is illegal, but for greater certainty, this would not be unless it's X and Y. That's redundant. Well, obviously, if it's not illegal, I would presume that we would not be here. Right? Why would you seek to make a defense to charges of hate speech? You say, well, no, it is hate speech. But that's not the sub argument. That's not the underlying embedded argument as to whether this is willful promotion of hatred. That's the top line, not the bottom line. So what you're doing is you made the entire, everything that's prior to that, if they do not willfully promote hatred, you made the entire section redundant. Please, sure.
So I mean, I think by their nature, for greater certainty clauses in the criminal law are essentially redundant in that they restate an existing legal principle to aid in clarification, aid in interpretation. And this, the objective of this for greater certainty clause, and I apologize if I'm repeating, but maybe I'll say it differently and or maybe more clearly, was to respond to concerns that were heard with that by repealing the good faith religious exemption defense, that there would be a risk that people who make good faith statements, good faith religious statements, would be captured by the offense. And it is not the view of the government or the minister that that is the case. And this is a for greater certainty provision to help clarify that the scope of the offense does not include that type of expression.
Unless it's promotion of hatred.
Correct,
But-
which is
but
which
that's
are the
problem.
elements of the
But
offense.
so it doesn't add the certainty, it creates more uncertainty. Because I'll say to you, well, my statement is in the public interest of a religious discussion. You'll say, okay, sure, but you're still willfully promoting hatred. In other words, I've accomplished nothing with this definition. But wait, there's more. Because I think you just hit the nail. I think you, Ms. Wells, you mentioned the most important words that are absent in this discussion and from this section, and the word is good faith. Which is why, by the way, the original section was so good. Because it started, if in good faith, the person expressed or attempts to establish by an argument an opinion on a religious subject or an opinion based on a belief in a religious subject. The word good faith is a prerequisite because that goes to intent. Because I might say something that may sound like hate speech, but if I said that in good faith, the mens rea, the intent element of the offense, would not be met. So I really hope, and I know that I've taken a little bit of time here, but there's at least 2 to 2.5 issues that are really sticking out with this amendment. And I want to say to Ms. Latanzio that we're prepared to work through it. We want to work through it. But we really need to consider whether we want to bring the words good faith into this. And it's remarkable that in your attempt to explain what the section attempts to do, you've used the phrase good faith twice, but the section doesn't have the word good faith. So I don't know. I think I've made my point about the section. Thank you.
Thank you, Mr. Housefather.
Thank you very much, Mr. Chair. Thank you very much, Mr. Chair. I listened carefully to Mr. Baber, and that's a discussion to have about the amendment itself, but we're on the sub-amendment right now of Mr. Lawton. And the sub-amendment, Mr. Lawton, is actually much, much worse than anything that could be wrong with the wording of the clause. So let's start from the principle that we removed a defense that has never once been successfully used in the history of Canadian courts. There is no change to the state of the law by removal of that defense. It simply says that somebody who was charged with willfully promoting hate cannot rely on a religious good faith defense to their willful promotion of hatred. As set out, we've already agreed on that we will use the Kijkerstra definition. We have already had the discussions, Mr. Baber, that we agree on a definition of hate. So if the bill inadvertently had a different definition, that wasn't the intent, and we will agree with you to go back to the definition that is in the Kijkerstra case. What we have here is, because there has been misinformation circulated since we removed the religious defense, telling people they won't be able to read the Bible or cite the Bible or teach in church or preach, which is completely untrue. Okay, Mark Miller never said what you're claiming he said, and I'm not going to engage in a back and forth with you, Mr. Brock. When you have the floor, you can have the floor. Nobody in this committee that voted on this had any section tension, and that's not what the law would be. The law didn't change in that respect. Nothing changes in who can be charged with willful promotion of hatred. And so this clause is being inserted to all those people who have been misinformed and confused by what people have said, whether truly or falsely. I'm saying what I absolutely believe. So people have been misinformed. This clause is stating again accurately what the government, what the members of the committee by majority believe the law to be. And what Mr. Lawton's sub-amendment does, is change the law. What Mr. Lawton's sub-amendment does would effectively mean that nobody could ever be charged with willfully promoting hatred in almost any circumstance. In any circumstance, which is, I think, having listened to previous statements by Mr. Lawton, maybe what he actually wants to do. He may actually not want people to ever be charged with willful promotion of hatred, no matter how much they vilify or attack a group, no matter how much it meets the Kijkerstra standard, because maybe he would have been a dissenting judge in the Kijkerstra case. I don't know. But for sure, what Mr. Lawton's sub-amendment does is change the law. So I would like to ask the officials, if Mr. Lawton's sub-amendment was adopted, if the committee removed the words that Mr. Lawton is seeking to remove, would that change the state of the law in Canada?
Yeah. What I can say, if I may, Mr. Chair, is it would certainly change the intent of the provision. I think one of the challenges is that this has been introduced as a for greater certainty provision. So it would no longer be appropriately a for greater certainty provision, because it would create, well, it would be inappropriately classified as a for greater certainty provision, because it would state the law in a way that it doesn't currently exist. So yes, it would change. I mean, I'm probably oversharing in terms of the legal impact of the for greater certainty piece, but yes, it would change the state of the law.
It would change the state of the law because there's no words in good faith in here. And I'm not disagreeing with other aspects of the wording. Maybe not be perfect. There may be other ways of expressing it. But what Mr. Lawton was proposing to do was actually change the state of the law. So essentially, nobody could almost ever be charged with willful promotion of hatred, no matter how egregious what they did was. That's the effect of Mr. Lawton's sub-amendment. What Mr. Lawton is proposing is to say, hey, the Supreme Court ruled this in Kijkerstra, forget it. Let's go back to what the dissent said in Kijkerstra. So, so let's deal with the sub-amendment. And let's vote against this sub-amendment. It's all my proposal. And then I'm happy to have good faith conversations with anyone about the clause itself. But the sub-amendment is a really big problem. Je dois vous dire que ça change complètement.
And I have to say that it completely changes the law.
Floor back, Mr. Chair.
Thank you. Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. With all due respect for Mr. Layton and my other Conservative colleagues, I listened closely to Mr. Layton, or perhaps Mr. Barber, who said that we have to be within the tunnel of the public interest statement. But that's not the real tunnel. The tunnel is the promotion of hatred. So if no one is promoting hatred as is prohibited in Section 319, anti-Semitism and hatred. So if someone is not promoting hatred or anti-Semitism, we don't need the for greater certainty clause. And I agree with what Mr. Housefather just said. It was proposed by our colleagues, the Liberals, to try to assuage the concerns that some people feared arose from the numerous public statements by our Conservative colleagues. And if I've understood them correctly, they perhaps have garnered some votes or funding through this debate, but who have made a number of comments about this bill since last fall, yelling on the rooftops to whoever wants to hear it that this is going to prevent people from reading the Bible, the Quran, and the Torah. So with all due respect, Chair, it is absurd. That is not what is in question here. We've never talked about it, and we never will. I can guarantee that I won't. We cannot prevent people from reading religious texts. That's not what we want to do. We want to prevent them from promoting hatred, and that is what 319 tells us. And so in order to try to quell the concerns that, in my opinion, were not justified, but it's possible that people do have concerns, even though I don't share them, well, our colleagues and Ms. Latanzio proposed 11.1 and said, no, don't worry. If you do not have the intent of promoting hatred, there's no problem. So that's what 11.1 states. So I think that 11.1 isn't even necessary. But, okay, fine, we're negotiating, so I can accept that 11.1 be added to C9 because of this situation. But now it's becoming an absurdity, Mr. Chair. And I can't quite understand the discussion that we're having, because if our Conservative colleagues think that 11.1 isn't helping them, well, I would invite Ms. Latanzia to withdraw 11.1 because we don't need it. That being said, I feel that we are coming to an impasse, Chair. Our Conservative colleagues, if I've properly understood what Mr. Brock was saying earlier, are being guided by religious lobbies that are saying, don't do this, do that instead, you refuse that, propose this. And to have my conduct as a parliamentarian dictated by any religious group or any group at all, be it religious or corporate, I will not have it. I state, and I am proud of it, I am a free person, a free politician who proposes to voters what I believe is best. So if I am told that Mr. Ross, who I don't know, but with all due respect to him, that Mr. Ross told Mr. Brock that you had to take this out or add this, I don't think that's an argument that's going to get us anywhere, Mr. Chair. And if our Conservative colleagues really are stuck because Mr. Ross wants something or doesn't want something, I don't see how we're going to get anywhere. So, Mr. Chair, the Bloc Québécois wants this. We want to preserve the secular nature of our institutions in Quebec and throughout Canada. We want to protect the secular nature of Canadian society and the respect of the rule of law, the same rule of law that applies to everyone, to all Quebecers and all Canadians. That is what our purpose is here. And what we have here before us is that the rule of law and secularism for anyone versus the will of certain religious groups that are dictated to their Conservative colleagues. And so, between what the Bloc Québécois is asking and what the Conservatives are asking, we want the respect of the rule of law and secularism, and the Conservatives want respect for religious groups. And well, then there's the Liberals who are trying to be able to try to save both sides and find a middle ground, and it gives us a solution that doesn't really say anything, and it's not going to say anything at the end of the line. So we've been working on C9 since last fall, and we've made some progress. But the religious defense that was in the criminal code, they haven't been abolished, but they were voted in this committee as having been set aside last fall. And now it's the end of February, and we're still talking about it. So when is this going to end? I don't know. But I suspect that we truly are at an impasse. And I think that as a committee, we're going to have to take a vote, and we're going to have to state a position. Are we on the side of religious groups and meeting all of the concerns of religious groups, be they founded or not, useless or useful? We don't know. Or do we decide that we are going to protect the rule of law and secularism? There's a criminal code that applies to everyone, regardless of religious beliefs, regardless of profession, regardless of where one lives in Canada, and that is the criminal code and that rule of law that should govern us. So, Chair, I am very unhappy to see that we are at this impasse. We have been there for a long time, but I think that if our colleagues were to propose that there be a closure motion, well, I would seriously think about accepting that, because without that, I don't like to say it, but I really think that there is some bad faith here or an intention to block our work, and we have to get out of that impasse. That's in the interest of all of our voters. We must work on behalf of the people who are paying us to be here, who voted for us, who elected us to be here, and not work in the interest of one or two religious groups. So I'm sorry. I have a great deal of respect for my Conservative colleagues and my Liberal colleagues, but now I think that we have reached our limit, Mr. Chair.
And Mr. Lawton.
I did not interject Mr. Fortin because I believe he has a right to express his opinions, but I would draw your attention, Chair, to a decision you made twice in December on this meeting, which was to eject two members for making a comment that you deemed imputed motive. Mr. Fortin imputed motive on us and our conduct. He said we are beholden to religious interests. He said we are allowing religious interests to dictate the decisions we're making and the advocacy we're taking. That is a motive that is not true. We are doing what we're doing because we believe in the values we're speaking about. But your own precedent dictates that that comment should be withdrawn.
I think what I did, Mr. Lawton, if you go back and look at the record, is I asked that member to stop talking, and I gave the floor to somebody else. Mr. Fortin is now finished speaking. Mr. Brock.
You asked him to withdraw the comment.
And they didn't.
And
Mr.
I would
Brock,
ask that you make the same request of Mr.
Brock,
Fortin.
Mr. Brock, you have the floor.
So are you ruling my point of order is invalid?
Yes.
I would challenge that, please.
All right, you're right to do that.
Monsieur le Président, est-ce que je peux répondre au...
Mr. Chair, can I answer? Can I provide an answer to Mr. Lawton's statement?
Mr. Brock, you have the floor. Mr. Brock.
You can't challenge a ruling on a point of order?
That's right.
What ruling can you challenge?
Thank you, Mr. Chair. I, too, share the same concerns that Mr. Lawton raised in a point of order. As I've said numerous times, and I will continue to say numerous times, I have the utmost respect for my colleague, Monsieur Fortin. But his choice of language hurt. It hurt our integrity. I agree with Mr. Lawton that although we receive, as the entire committee receives input from many stakeholders, in this case religious stakeholders who have been following this debate since the fall and have tried to assist all committee members to fully understand their position, but by no means can you conclude or construe from that we are beholden strictly to certain religious groups. I can tell you what we are beholden to, and we're beholden to the Canadian Charter. And our party stands for the right of freedom of expression and freedom of religion, which is under attack by this particular poison pill block amendment. Now, Mr. Fortin tried to frame this as a philosophical, intellectual divide between the Bloc's position and the Conservative position. And I think indirectly painted the picture that it was the Liberals who are the moderates here, that it's the Liberals who are trying to bridge this philosophical difference between the two parties. And I've said this numerous times, and I think it bears mentioning again. And I'm going to turn to the officials for greater clarification on this. Bill C-9 was introduced by Justice Fraser, Minister of Justice Fraser, in the fall of 2025. Nowhere in the draft of the bill was there any reference to the Liberal government seeking the removal of a 56-year-old defense under Section 319. And I say that, I've said it numerous times, because it's important for all the stakeholders and Canadians who are watching this, that the Liberals are by no means the saviors here trying to come up with an agreement that everybody can live with. The Liberals never intended, when this bill was drafted, when this bill was presented, when this bill was debated at first reading and at second reading, and when this bill was actually studied, and I don't know how many meetings, Mr. Chair, we've had in terms of this particular bill and how many witnesses were called, not one specific expert witness or subject matter expert on the issue of the removal of this decade-old defense was ever called. Now, Mr. Fortin, as he had every right to do, made it abundantly clear that this was ultimately his position and used pretty much every opportunity to expand upon his concerns about the removal of the defense and to get some evidence from some of the witnesses. I don't recall any Liberal member on this Justice Committee ever expressing or displaying any support for Monsieur Fortin's line of questioning to remove this religious defense. Until late in the fall, when we as parliamentarians received the news that one weekend that the Liberal government, ostensibly by Sean Fraser, our Justice Minister, had decided to create a backroom deal with the Bloc Québécois that in exchange for the Bloc to support passage of Bill C-9 at all stages, that they would now, some, 6, 7 months removed, now saw merit in removing a 56-year-old defense. So with that as the backdrop, officials, please help me with this. Were both of you ladies involved with all the stakeholder consultations that Sean Fraser engaged in terms of formulating his position on how he would instruct you to draft the original Bill C-9? Were you part of those stakeholder discussions?
And engaged on some and through our own processes as well, where officials have direct engagement with stakeholders, but we are not party to all of the conversations that the Minister's office has with stakeholders.
If you know, if you don't, you don't. But when can you tell us that those discussions began?
And which discussions are you referring to specifically?
In terms
Mr. Brock?
of creating the anti-hate bill, Bill C-9.
So elements of it were part of the government's platform, including the proposed new offenses for obstruction and intimidation. You'll also recall that other elements, like the proposed new hate crime offense, were part of former C-63, so have already been introduced. So work on this issue and these related issues have been ongoing at the department for several years.
But after the spring election in 2025, we as parliamentarians were led to believe, because of statements made by the Justice Minister and other ministers and the Prime Minister, that extensive discussions and meetings took place, which enabled the Justice Minister to deliver instructions to his department to create Bill C-9. How soon after the election, if you know, tell me please, how soon after the election did those meetings start? And when did they end? And when did you get instructions from Sean Fraser to create Bill C-9?
I can't recall the dates. I mean, I think what I can say is the department has long been working on these issues. Part of our role at the criminal law policy section is to be ready when asked, to prepare. And so I think to be helpful.
Give me exact dates?
I can't give you an exact date.
That's fine. I didn't think you would have that, and that's fair. But is it also fair to conclude that some of those stakeholder discussions, whether they be in person, whether they be Teams
Chair?
or
point of
Zoom, or simply exchanging correspondence, also included stakeholders from the province of Quebec?
Mr. Brock, sorry we interrupted, but we have a point of order.
Sorry, I have a point of order, Mr. Chair.
Yeah.
I don't know where the line of questioning is, how that is related to Mr. Lawton's sub-amendment. I think that we're still on Mr. Lawton's sub-amendment with regards to removing the last line of my for greater clarity, certainty clause. Is it not, Mr. Chair?
That's a fair point of order, Mr. Brock. Perhaps you could bring it back in, yeah, that's all, yeah.
Lots to ask and lots to say.
Understand the pertinence of this questioning on consultation, and if officials were on consultation process, how that is related to Mr. Lawton's sub-amendment.
I'll get to that, but I'm not going to be put on a clock by you, Ms.
All right,
Latanzio, or anyone else.
The back and forth, it's a fair point of order, Mr. Brock. We have to keep it relevant, so carry on.
Fair enough. So I think I formed the question before I was interrupted with a point of order. Any discussions whatsoever with stakeholders from the province of Quebec?
Specifically, I can say generally that the department, at the very least, does have broad opportunities to consult with all provinces and territories.
Okay. Do you recall, if you were party to these discussions or received information from the Justice Minister, of any stakeholders prior to the creation of Bill C-9 specifically asking for the removal of the religious defense as contemplated by the Block Amendment? Yes or no?
I think what I can say to that, Mr. Brock, in the interest of being helpful, is that we have been aware at the department for a long time that the good faith religious defense exception has been of concern for various stakeholders, and that there are various views on it. And I think to bring it back to your opening remarks, you will see that and you know this, that when C-9 was introduced, as you indicated, it was not part of the proposed legislative package.
Because it wasn't a priority for the Liberal government at that time.
I can't speak to the priority. I can tell you it wasn't part of the C-9 package.
If it were a priority, common sense would indicate that we would have saw some reference in Bill C-9 from the Liberal government telegraphing a removal of the religious defense, that the religious community in Canada has enjoyed for 56 years a law that was created by a Liberal Prime Minister, Pierre Elliott Trudeau, in 1970.
Sorry, question? I'm just,
No, it's,
Okay.
I'm putting a statement on the record. Okay, we'll ask questions, but I just wanted to put that on the record. Thank you. Were you privy then to the change in direction that the Liberal government made in late fall of 2025 to agree with the Bloc that they would seek the removal of this defense? Were you consulted beforehand? And I'm not asking what the opinion was, so don't claim solicitor-client privilege, but were you asked to
Mr. Chair,
provide
point
a
of order.
legal opinion?
Mr. Brock, we have a point of order. Ms. Latanzio?
Mr. Chair, again, a question of relevance. We're not discussing, or the questions to officials
Okay, for relevancy, I'm going to go back
Just
to the
Mr. Brock,
sub-amendment
I'm
for
going to
Andrew
Lawson.
hear, I'm going to hear the point of order,
Okay.
Mr. Brock. Go ahead, Ms. Latanzio.
Again, the questions or comments being made to officials or to this committee have nothing to do with Mr. Lawton's sub-amendment. And it is very clear what is happening before our eyes yet again. So, again, Mr. Chair, can we just keep the questions or the comment relevant on Mr. Lawton's sub-amendment?
Yeah, I think we all agree on that, and I agree that the individuals here are responsible for drafting based on instructions, Mr. Brock, so maybe we can keep that in mind.
Yes, well,
Thank you. Carry on.
officials, were you involved in the drafting of Ms. Latanzio's amendment?
Of the legislation, I said.
Of this particular amendment that we're discussing today? Sure, so
C9.
there's my relevancy link, okay? So you have been involved with drafting.
Bill
Not-
C9 is what I said, sorry.
Exactly.
Yeah, and then
Right.
we continue to provide support to our minister's
Absolutely,
office
so
as
there
requested
is my
on various
path
issues.
of relevancy, all right? So Ms. Latanzio can continue to interrupt for the next 15 minutes. I'm not going to prevent her from doing that. That's her absolute parliamentary right, but it's also my right to ask relevant questions. And relevancy is subjective because I have the right to ask questions that allow me to put a foundation before you before I actually talk about the merits or lack thereof of Ms. Latanzio's amendment.
Sorry, can I clarify? Was your answer that you were involved in drafting the legislation but not the amendment, correct?
To clarify, my answer was that we were involved in the drafting of the bill, and that following the introduction and to the committee study of the bill, we continue to provide support to the minister's office on the parliamentary process.
Support.
Thank you.
Okay? And by extension, support could also include aiding with the drafting and the specific language used in Ms. Latanzio's amendment known as 11.1 sub 1. Correct?
So I mean, I'm mindful now of maybe where we are on the line of solicitor-client privilege, and I am aware of
Asking
as well
you
as
for the
parliamentary
advice you
privilege.
gave.
So I think the only way I can answer that is just to continue to reiterate that we do support the minister's office in this area.
And the minister's office, by extension, includes his parliamentary secretary, correct?
I mean, presumably, but we don't see that distinction all the time. So our direct correspondence is with the minister's office.
I get that, but there's one parliamentary secretary assigned to every single minister of the government. I can understand why you wouldn't be consulting directly with Mr. Chang, without insulting you, Mr. Chang, with all due respect, or Ms. Dillon or Mr. Housefather. But it's obvious that Ms. Latanzio is an extension of the Minister of Justice. So she would be included. Whether you want to agree with that or not, I think it's just common sense that you would include a parliamentary secretary. So again, I don't want you to say this is governed by solicitor-client privilege, but were you asked to provide a legal opinion prior to the declaration that was leaked to the national press in late fall of 2025 that the Liberal government was now prepared to agree with Mr. Fortin's amendment to remove the defense. Were you consulted, yes or no,
Point d'ordre,
by the
Monsieur le
Minister of
Président.
Justice?
Mr. Fortin has a point of order. Go ahead,
En
Mr.
tout
Fortin.
respect, Monsieur le Président, je pense pas que la
Respectfully, Mr. Chair, I don't think that our colleague Mr. Brock's questions are relevant to our debate. The questioning is going in the direction of undermining or questioning, rather, the credibility of a witness. And here we have officials of the Justice Department who are there to clarify points of law with regard to the legislation that is before us and the amendments thereof. So to ask them whether they took part in the positioning of the government in favor or against an amendment to the bill or a proposed amendment to the bill is not relevant. I agree that our colleague, Mr. Block, can ask questions about interpretation. I mean, Mr. Lawton, I'm sorry, I said Mr. Lawton, but in fact it was Mr. Bobber, but who was asking how should I interpret such a passage in the proposed amendment. That's fine, but to ask whether Ms. Wells participated in discussions with Mr. Fraser and Ms. Latanzio in October, and whether they said that they were possibly in agreement with an amendment that the Bloc proposed, I do not see a link of relevance, and it does not advance us in the text that we have before us.
Mr. Brock, I'm inclined to agree, with Mr. Fortin, rather. I mean, you can ask questions about their interpretation of the language that we're discussing. You can ask them questions about the drafting of the bill, but getting into discussions they had with the minister and, by extension, the parliamentary secretary, we're treading on dangerous ground, and it's, in my opinion, it's not relevant. So if you could sort of maintain those goalposts, I would appreciate it. Thank you.
Thank you. Thank you, Chair. I can move on. So I listened very carefully to Mr. Housefather's intervention. And Mr. Housefather essentially said that there's a great deal of misinformation. And although he didn't point any fingers, I would certainly surmise he wasn't looking at his bench, certainly wasn't looking at Monsieur Fortin, but by elimination, he was probably accusing the members here of the Conservative Party of being the authors of that misinformation. And when challenged, when that comment came out, I raised the comment, and I'm sure Mr. Lawton did as well. We both suggested Mark Miller. And I recall Mr. Housefather saying something to the effect that Mr. Miller did not say what we were alleging that he did say. So I actually have the transcript of when Mr. Miller, who's now a minister of this Liberal government, was in your chair, Mr. Chair, and this was a question, a follow-up question after all the rounds had been exhausted to Mr. Derek Ross. And it reads as follows. I'll use Chair's prerogative to ask a follow-up question of Mr. Ross. As despicable and as unlawful as the statements made by Mr. Charkaoui are and would be if they were stated again, we don't know why the prosecution chose not to continue with the charges. Perhaps this is to Mr. Fortin's point. I want to dig a bit into the concept of good faith, Mr. Ross. In Leviticus, Deuteronomy, and Romans, there are passages with clear hatred towards, for examples, homosexuals. I don't understand how the concept of good faith could be invoked if someone were literally invoking a passage from, in this case, the Bible, though there are other religious texts that say the same thing. How do we somehow constitute this as being said in good faith? Clearly, there are situations in these texts where statements are hateful. They should not be used to invoke or be a defense. Now, here's the important passage. There should perhaps be discretion for prosecutors to press charges. I just want to understand what your notion of good faith is in this context, where there are passages in religious texts that are clearly hateful. That was, Mr. Chair, before the agreement was reached between the Liberal government and the Bloc Québécois that had absolutely nothing to do with what's in the best interests of this country, but what's actually in the best political interests of this Liberal Party and Liberal government. And Mark Miller, who is now a minister, sent a very strong message, sent a chill down the spine of every single religious leader, follower, and everybody in between in this country that this Liberal government has now declared war on freedom of expression and freedom of religion. That notwithstanding some of the passages that this minister referred to are over 2,000 years old, he invited prosecutors to press charges. So with all due respect, Mr. Housefather, that, sir, is misinformation that did not come from any Conservative member. That came from your colleague, your minister, Mark Miller. He lowered the gauntlet. He created the division that we are now seeing in this country. And all the peddling that this Liberal government is doing right now with language, trying to placate Conservative members, trying to placate our party, trying to placate all religious leaders who have written every single member at this committee. I know that there are civil liberty groups who have jumped on the bandwagon and saying, how could this government wage war against our protected charter rights? Why attack? And to Mr. Housefather's point, I agree with him. That religious defense has not been successful at all. But does that give license to this government to actually take steps to remove a religious defense that has guided and protected good faith discussions, statements, and opinion across this country? Absolutely not. To the officials, when was the last time a federal government actually removed a statutory defense in the criminal code? You have any idea?
It does happen.
Yeah. You know how long ago it was?
If you know the answer,
Yeah.
please, you can remind me.
2015. Okay? And prior to that, (2015) was the narrowing of the provocation defense. Prior to that, it was 1995, which was the limitation of the extreme intoxication defense. And even further prior to that, in 1983, the repeal of the marital rape exemption. This doesn't happen a lot, does it? In legal jurisprudence, that we actually take as a government legal steps to remove a statutory defense.
In my experience, it's more likely that that offenses are added. there aren't many statutory defenses. A lot of it comes from the common law as well, as you know, Mr.
And you'd
Brock.
agree with me that quite often when statutory defenses are removed, that largely it's guided by common law decisions?
I think that's true in some cases. I'm not intimately familiar.
Right.
I'm aware of the examples that you cite,
And
but
in
I'm
this
not intimately
particular,
familiar with
on this particular issue, there is no common law decision out there that would give license to this Liberal government to now make a political decision where they had ample opportunity during the drafting of Bill C-9, where they had ample opportunity to debate this issue in the House, where they had ample opportunity to debate this issue at Justice Committee, now to say, we think this is the right thing to do for this country. They made that decision on their own. They did not make that decision because they were guided by legal decisions across this country. Is that fair to say?
his reading of the Keegstra decision, which is not an immediate decision. It is an older decision, but using that guidance, the ministers of the view that the good faith religious exemption defense, given the way that the offense was interpreted in Keegstra, doesn't do.
And when was Keegstra released? What year was it released?
I have to look it up. It's, I think, in the early 90s.
It certainly wasn't in 2025.
It was not 2025, correct.
No. In fact, it wasn't even in this century, was it? Wasn't in the century.
I believe it's 1990, but
Exactly.
I would have to confirm.
Thank you, Chair. That's my time.
All right, we have a few minutes left. Ms. Latanzio. Sorry, then you.
Yeah, I'm next.
I had it wrong before.
Okay, that's Mr.
We've only got a couple minutes, but go ahead.
Mr. Chair, I just want to make a few comments before, and I don't know if I'm going to have time to get to Mr. Lawton's sub-amendment, but I think it's important to state at this point that our minister and our government have acted in good faith at every step of this legislation on C9. In a minority parliament,
order.
we know that collaboration is not optional but necessary. We have worked
Sorry,
with
Ms.
all
Latanzio.
parties, including tonight, to negotiate.
Sorry, we do have a point of order.
So Ms. Latanzio's own admission right now is that she is not speaking about the sub-amendment. She says she hopes to get to it eventually. Given your direction that you've given us, Chair, on the importance of relevance.
And I'll give her the same latitude I gave Mr. Brock. She's laying the foundation for what she's getting to, which is what she said. Okay.
We know that in a minority parliament, collaboration is not optional but actually necessary. We have worked with all parties, including this evening, to negotiate language that protects Canadians from hate and intimidation while at the same time upholding the Charter. This bill is about protecting real people in real spaces. Canadians walking into a mosque to pray, families attending a synagogue on a Friday night, children going to school wearing a hijab or a kippah, community members attending pride events, or volunteers gathering at a cultural center. No one in this country should face threats, harassment, or willful incitement of hatred simply for who they are or for what they believe. What happened here this evening is straightforward. We've asked the Conservatives to end the obstruction and to stop the filibustering so that the committee could do its work and move this bill forward. We took 35 minutes of this committee time to talk in private in order to decide whether they could commit to ending the filibuster, and ultimately they refused. Conservatives have now filibustered this bill, C9, for more than 50 hours, Mr. Chair, 50 hours of delay on legislation designed to protect Canadians from hate and intimidation. And the meeting is going to end in a few minutes, and C9 did not move forward this evening. We remain ready to work, but Canadians expect Parliament to function and not be stalled indefinitely for partisan reasons. The Conservatives need to stop stalling, stop shielding delay behind the process, and let this bill move forward. If they will not stand with us, they should at least get out of the way so that we can stand with Canadians. And now to Mr. Lawton's sub-amendment. I think it's important to read in the record once again, Mr. Chair, remind Canadians what exactly the intent of this sub-amendment is. And I quote, hate propaganda. What we've inserted or suggested for the greater certainty of this clause in 11.1 would state, for greater certainty, nothing in subsection 319.2 or 2.2 of the Criminal Code shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate, if they do not willfully promote hatred against an identifiable group by communicating the statement. Mr. Lawton's sub-amendment would remove if they do not willfully promote hatred against an identifiable group by communicating the statement. This would do away with the Keystra decision and the common law precedent that we have. And therefore, what this would do is allow not anyone ever being charged for hate. So this is what we're called upon to be able to vote on, Mr. Chair. This is what the proposal is from the Conservatives right now that's sitting on the table. They are asking us to do away with the Keystra decision, common law, well-known, as Mr. Brock has pointed out, a well-known and old decision that courts have been using, but Mr. Lawton is suggesting to this committee that we do away with that and not have anybody ever charged for willfully promoting hate. I think it's important to put this into context, and I understand that we've come to the end of our committee and yet again not disposed of C9.
Thank you, Ms. Latanzio. On that note, we'll adjourn the meeting.